Earlier today, our government introduced an act respecting countering foreign interference, a bill which would give Canada new, modern tools to combat foreign interference. Canada is a strong, open, and free democracy. These strengths, however, can make Canada a target for those who wish to advance their interests to the detriment of our own. To achieve their aims, foreign states may recruit witting or unwittingly individuals to assist them on Canadian soil. They may also attempt to silence dissidents and promote narratives that are favorable to their country in a clandestine manner. Such actions constitute foreign interference. It is a deliberate attempt to disrupt the fundamental values and freedoms that, as Canadians, we cherish and that are at the very heart of our free and open society. Malgré le fait que la menace posée par l'ingérence étrangère
of foreign interference, its scope has gotten more sophisticated over the past years. Today, foreign interference is one of the greatest threats to our sovereignty, our economic prosperity, and our way of life. Thanks to the extraordinary efforts of CSIS and the RCMP, Canada is still able to combat this threat. And in a world that is more and more digital, the nature of the threat has evolved.
With an act respecting countering foreign interference, we're taking action to adapt and to respond to a world where life and consequently threats are increasingly moving to the online realm. First, this legislation would create a foreign influence transparency registry. Under this registry, all individuals or entities who enter an arrangement with a foreign government or entity and who undertake activities to influence a government or the political process in Canada would be required to publicly register these activities. This registry would be overseen by an independent foreign influence transparency commissioner who would be responsible to administer the Act and to promote compliance with the Act as well. Tout au long de nos consultations, les individus et les organisations
individuals and organizations have told us that a transparency mechanism would be an indispensable tool to counter foreign interference. It's also become clear that a registry should be accompanied by other initiatives. Consequently, we are also proposing 4 basic laws. The Canadian law on security, criminal code, law for information security, and evidence law in Canada. These modifications on the laws would provide the service better tools to fight foreign interference and protect our communities. This law was put forth in 1984 at a time when the widespread use of digital technology had not even been considered.
Digital technologies are a part of every aspect of our lives, and this new context calls for CSIS to be more agile in how it can conduct its investigations. This is precisely what this legislation would achieve. Crucially, it would also enable CSIS to share information with key partners outside the Government of Canada. This information would help our partners, provinces and territories, universities, and private companies build resiliency to foreign interference. This element has been called for by business organizations and provincial leaders alike for some time now. A resilient and informed population is our best defense against foreign interference. We'll keep taking action as a government to protect Canadians from those who would try to work against our national interest. And to further expand on these changes, I will now turn to my colleague, the Minister of Justice and Attorney General of Canada, Arif Virani. Arif, à toi.
Hello, bonjour. Merci, Dominic. Thank you very much for that.
you.
And thank you to all of my colleagues. This is certainly a governmental initiative that a lot of people are interested in. I wanted to address some of the justice-specific pieces of this package. This legislation makes three important changes in the area of our justice system. First, it makes amendments to the Security of Information Act. It also modernizes the sabotage offense in the Criminal Code. And finally, it introduces a mechanism in the Canada Evidence Act for the protection and use of sensitive information in the review of federal administrative decisions in the federal court and the Federal Court of Appeal. So looking at these in a bit of detail, on the Security of Information Act, that is a key tool to allow law enforcement to investigate and lay criminal charges related to conduct that may be harmful to Canada. This includes activities involving foreign influence threats or violence. The bill makes several key amendments to this legislation. It creates new offenses to better address foreign interference risks to Canada and to ensure that covert hostile activities are fully addressed by the criminal law. For example, this could include someone who knowingly facilitates the entry into Canada of agents of a foreign entity who are posing as merely tourists. It enhances our ability to address transnational threats or violence by foreign governments and those who work on their behalf, who attempt to intimidate people living in Canada and their families abroad, a very key facet. It also expands the preparatory acts offense. Here we are talking about anything done in the preparation of the commission of an offense. Espionage, for example. The amendments cover preparatory acts for both existing and new offenses, as well as enhance the existing penalties. Other changes to the Act would address the inappropriate sharing of military knowledge and amend the definitions of persons who are permanently bound to secrecy to include units within the Canadian Armed Forces. Passons maintenant au code criminel. Nous
Now,
proposons des
with the
modifications pour
criminal
moderniser nos lois et faire face aux
As Dominic
menaces
said, our
nouvelles
laws are
et en
threatened,
évolution
new
d'ingérence
threats,
étrangère.
and the progress of foreign
Le
interference.
projet de loi vise à préciser
This
les
bill
catégories d'infrastructures
aims to
essentielles
specify
protégées,
the
y compris
infrastructure
les systèmes d'infrastructures privées
definitions
nécessaires au transport
and
et aux
the
communications,
as public
ou la
and private
prestation-
services, transportation,
prestation
communications,
des services de
or
santé
service
et
delivery for in
l'approvisionnement
health
alimentaire.
and
Dominic
food
vient de
supply.
mentionner le fait que
Dominic also
des
mentioned the fact
projets de
that
loi n'étaient pas changés depuis les
this
années
bill
80. En
has
termes
not
de
changed since
sabotage
the
et en termes de
80s,
cet aspect-là,
and so
les
under
changements
this,
datent des années de
these changes
1950. Donc, c'est
date back to the
là, il est dans le temps
1950s,
de
so it's
modifier
now
nos
time
propres lois.
to organize our own
Dans le
laws.
cadre de l'infraction, des protections de la charte
In terms of the
à la
interference,
liberté
the Charter
et à la liberté
guarantees
de
freedom
réunion
of
pacifique.
expression
Donc,
and
les deux
freedom
sont
of
précisés
gathering.
dans le propre projet de loi.
They are specified
Créer
in
une
the
nouvelle
bill,
infraction
creating
si dans la
new
possession de la
infractions
vente d'un dispositif en
for
vue
selling a
de
device
commettre un acte de
to
sabotage.
commit
Parmi ces
sabotage.
appareils figurent les bots,
Also,
des dispositifs
including
connectés à l'Internet,
devices
dont-
connected
dont
to
certaines sont
internet
infectées
bots.
par des
Some
logiciels malveillants.
Are backed by
Finally, the bill also
evil
improves
people.
how sensitive national security information is protected and used in federal administrative proceedings in the federal court and the Federal Court of Appeal. This includes creating a new process under the Canada Evidence Act. This will provide a mechanism for the federal court or the Federal Court of Appeal to consider and protect sensitive national security information when conducting reviews of governmental decisions. This new process would apply when such sensitive information is part of the legal record. The bill also amends Section 37 and Section 38 of the Canada Evidence Act. These amendments provide that, absent exceptional circumstances, any decision not to disclose specified public interest or national security information should only be reviewable by a court after the conclusion of the criminal trial and only in the event of a conviction. In other words, as part of an appeal by an accused after the conviction. This proposal seeks to address concerns about trial delay and trial interruption. It would also address issues related to court efficiency and court resources by ensuring that appeals are not launched by defendants unless there is actually a conviction. Finally, there are measures directed at ensuring that national security considerations will be expressly included in the list of reasons for a judge to consider when deciding whether to issue a sealing order in relation to a criminal code warrant. Together, these pieces will better safeguard the integrity and security of our institutions and our democracy, and will better protect people in Canada from the threats posed by foreign states and those who act on their behalf. This is being done in a way that respects charter-protected rights and freedoms such as freedom of expression and peaceful assembly. We are not doing this in a vacuum. We are following our allies like Australia and the United Kingdom, who have recently amended and strengthened their own foreign interference laws to deal with the threats that we all face today. This bill is also informed by what we've learned during public consultations over the last several months. The Department of Justice engaged with provincial, territorial, and Indigenous partners, academia, the legal community, and diverse communities and diaspora communities right across the country. We've heard broad agreement that we must take action against the growing threat of foreign interference in our country. This bill is the product of that input. It is a measured but robust approach to protect our national security, our way of life, democratic values, and our sovereignty. Thank you very much. Merci beaucoup. We are open for your questions.
Monsieur pourquoi insister sur le fait que le registre
Why
n'est
insist
pas une
on the
liste noire?
fact that the registry is not a blacklist?
On a mis l'accent là-dessus aujourd'hui, par exemple, dans le briefing technique. Pourquoi est-ce que
In
ce
the
nouveau
technical
registre n'est pas
briefing,
une liste
why
noire, d'après vous?
is it not a list, a blacklist, this registry? As Eddie has said, well, it's done with allies of Canada. There are other examples of registries in Canada. It's a way to increase transparency. We heard for a long time, especially from the diaspora communities, who said they wanted more transparency as to who is representing a foreign government. I don't think that if people are loyal to their legal obligations, are transparent, I don't think it's necessarily a blacklist. I think it's one tool among others. It's not a solution, a complete solution, but it's one tool that I think is important. Discouraging clandestine behaviors like they did in the past that gave birth to this foreign interference.
On the timing of the bill, what parts of this bill will actually be in place before the next election campaign scheduled? I know it could change, but if it's scheduled for September 2025, October 2025, what parts will actually be in place?
We would hope that all of this legislation will be in place. We don't intend to procedurally delay our own legislation.
But for
We
example,
intend
on
to
the
work. We
registry,
intend
it
to
wouldn't-
work with
the timing
opposition
is why
parties.
not?
We intend to work with opposition parties. We recognize that in an ideal circumstance, this legislation would be in place expeditiously. But we're in a minority parliament. We're going to work with opposition parties. I'm hoping that the effort around this legislation, the opposition parties have been calling for many months for a foreign influence transparency registry. Our hope is they'll work with us so we can put it in place, but we want Parliament to be able to do its work. But we
it sets
intend to
out a
proceed
year-
quickly.
It sets out a year for royal assent. So if it's a year after royal assent, for example, to create the registry, how would that be in place? It would have to be passed next month in order for the, like, royal assent, Senate and the House would have to pass it next month for the registry to even
So-
have a chance at being in place.
So again, the legislation was introduced 2 hours ago. We will be working expeditiously with opposition parties and our colleagues in the Senate. I'm not pessimistic that we can't build a consensus around the importance of having this legislation in place as quickly as possible. And our objective will be to work collaboratively with opposition parties and our colleagues in the Senate to do exactly that.
During the public inquiry, your government repeatedly said that intelligence is not evidence. So with the creation of these new offenses, how are you going to be able to make sure that charges are laid and people are actually brought to accountability when intelligence is not evidence, as you say?
Well, the intelligence to evidence continuum is a bit of a legal nicety, but it's really, really critical to understand. So when authorities, law enforcement authorities are gathering material, they're gathering intelligence. It transfers into an evidentiary realm when it is used in a proceeding, whether that's an administrative proceeding or in a criminal proceeding. What we're doing with this kind of measure is we are ensuring that we're providing the ability to have this discussion taking place, but ensuring also that there are safeguards in place. So this is a bit specific, but I'll walk you through part of it. There are contexts in an administrative sense, for example, where you might have national security information that relates to someone's immigration status or whether they have the ability to maintain status in this country under the Immigration and Refugee Protection Act. What we're saying is that sometimes when you need to use that intelligence as evidence in those types of proceedings, you need to make sure you have certain safeguards in place. And we're ensuring those safeguards through the use and permitting this idea about a special counsel who would be there in those sensitive hearings, safeguarding the interests of people that are not permitted to be in the room because they don't have the adequate security clearance. So it's important that we address this issue. It's important that we always uphold the protections that are in our Constitution with respect to individuals that are in our court system.
That apply to something like the
Juste en français.
Ouais. Est-ce qu'avec les